Inevitably, you or the other side are likely to fail to observe some of the rules. Rule 6 says that normally this does not render proceedings or a step in the proceedings void. What it does mean is that the tribunal can take such steps as it thinks just. Now, these steps include waiving or ignoring or letting you off the breach, but can include striking out all or part of the claim or defence, barring or restricting a person from participating, and awarding costs. There are exceptions where compliance is strict. Presentation of the claim, Rule 8.1, or the response, Rule 16.1, or the employer's contract claim, Rule 23 and 25. And then there are those orders which are known as unless orders. These are orders where the tribunal says, if you do not do X, Y, or Z, then your claim, your defence, will stand struck out. And very often they'll use the form of words, unless X, Y, and Z happens, the claim or the response stands struck out. Those are strict, and if you don't do what you're supposed to do by the time they tell you to do it in the unless order, then there is nothing else the tribunal needs to do. Automatically the strikeout occurs. So that's a strict provision, and that's in Rule 38. And then finally, under Rule 39, orders for deposits, which require you to pay sums of money. So if you haven't done what you're supposed to do, namely pay the deposit by the date provided, then the consequence is automatic, and that is strictly construed. One of the features of the new rules is that mediation and alternative dispute resolution are given more prominence. There is a fee for judicial mediation, and we'll come on to those in later talks in the series. But under Rule 3, the rules state that wherever practicable and appropriate, the tribunals will encourage the use by the parties of the services of ACAS, judicial or other mediation, or other means of resolving their disputes by agreement. So we've now finished with the general and introductory parts of this introduction to the tribunal rules. We'll now move on to consider preliminary hearings and the interim orders a tribunal can make, and from then look at the full hearing and what happens after hearings, including costs.